There's an allegation that the client may have been masturbating. That is not a crime to masturbate. Nowhere in our law is that deemed a crime. And under the elements, I will obey all laws. I must prove the elements of the crime alleged. There is no crime. There's no statute.
Okay, so what we are about to watch is the parole revocation hearing for what Richard and I have deemed as the King Roach, and you'll see why as this hearing progresses. But he was found guilty of sexual assault in 2016, and since then, he's really, I think this is the third time he's been revoked. And it's quite different in Connecticut, these revocation hearings. It's much more like a court proceeding. You see his public defender that really puts up a fight. He goes head to head with the parole officer, and then they make their verdict right at the end of it. With that, let's jump in, and at the end, I'll unpack all the details of really this King Roach. With that, let's jump in.
Okay, go with him. Yeah. Okay. I'm not gonna lock it up this so you're finished. All right. So good morning. I am Pearl Boyer. I'm a hearing examiner for the Board of Pardons and Parole. This is a revocation hearing concerning David Mara, inmate number 413857. Today is Wednesday, January 17th, 2024, and this hearing is being conducted by a video at the Board of Pardons and Parole Central location in Bridgeport Correctional Center. This is a public hearing, and public access to this hearing is available via live stream. Sir, could you please state your full name and DOC inmate number for the record?
David Mara, 413857.
Thank you. We also have counsel here. If you could please identify yourself for the record.
Good morning. Public Defender Robert Famagletti of the Parole Revocation Unit. Hello, Mr. Mara.
As well as your parole officer, if you could please identify yourself for the record.
Sure. Parole officer Danielle Monroe.
Thank you very much. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not that the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So first thing we're going to do, Mr. Mara, is we're going to go over your rights. You have the right to be represented by an attorney at this hearing, which you have exercised here today. You have the right to receive written notice of charges of violation. Did you receive written notice, sir?
Yes.
You also have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine any adverse witnesses. Do you understand these rights?
Yes.
And Attorney Famagletti, have you had sufficient time to prepare for today's hearing, and are you ready to go forward?
Yes, yes. And I'm not certain if Mr. Mara will testify at the end, so you may want to swear him in.
Okay, fantastic. So what we're going to do is for the people that are going to be testifying, which is going to be Mr. Mara as well as Officer Monroe, if you could please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth? So help you God, or upon penalty of perjury?
I do.
I do.
Okay, thank you very much. So what we're going to do first is we're going to review the charges that Parole and Community Services bringing against Mr. Mara and the information underlying each charge. So Officer Monroe, if you have
Charge-
those charges right there, charge 1 under obey all laws specific to
Yes.
obedience to the law.
Yep. On June 9th, 2023, Hampton Police was dispatched to Hampton Healthcare Center for a disorderly conduct complaint involving David Mara. The Hampton Healthcare Maintenance Manager completed a written statement of the incident. Due to the incident, a warrant for disorderly conduct 53A-182 with a $1,500 bond was approved and set by the Honorable Judge Cronin on June.
I'm sorry,
Yep.
Officer Monroe, I'm going to just stop you for one moment. I am looking at the one that was dated for 9/25/2023. You served him twice, is that correct?
Yes, I did.
Oh, you're muted. You hit the mute button by accident. Technology, it's so sensitive these days.
I'm sorry.
No,
I'm
that's
June-
okay. So let's just start over on charge 1, obedience to the law, and we're reading off of the notice that was served on 9/25/2023.
On June 9th, 2023, Hampton Police was dispatched to Hampton Healthcare Center for a disorderly conduct complaint involving David Mara. While the maintenance manager was attempting to move you to another location, you became very hostile towards staff. The maintenance manager stated that while attempting to speak to you, he took your back brace while he was seated and swung it at his face. The Hampton Healthcare Maintenance Manager completed a written statement of the incident. Due to the incident, a warrant for disorderly conduct 53A-182 with a $1,500 bond was approved and set by the Honorable Judge Cronin on June 15th, 2023. As a result of the warrant, you are in violation of your parole condition, obey all laws. In addition, on July 10th, 2023, an incident report was filed with the New Haven Police Department against David Mara regarding a sexual indecency with a night nurse at St. Renfields Hospital on July 9th, 2023.
And if you could read the evidence from
Sure.
that one.
Exhibit A, remand to actual custody order. Exhibit B, notice of parole violation. Exhibit C, parole rights. Exhibit D, parole violation. Exhibit E, parole conditions. Exhibit F, Hampton Police Warrant number 23-19487. Exhibit G, New Haven Police Incident Report number 23-027674. Exhibit H, notice of parole violation number 2.
Okay, and I would just like to mark for the record, I'm going to change the notice of parole violation number 2. I'm going to include that with Exhibit B. Exhibit H is now going to be the letter from Officer Monroe, and Exhibit I is the letter from Christian Shea, the Health Management Administrator for the DOC. In addition, we have received an addendum from Parole and Community Service. So addendum 1 reads Mara's disorderly conduct, Connecticut General Statute 53A-182 under docket ending in 4533 was nollied on November 9, 2023. Addendum 2 states additional information from Parole and Community Service Field Officer would like the Board of Pardons and Paroles to consider prior to his hearing. It is uploaded in the file attachments entitled David Mara. That became Exhibit H. Addendum 3 is on November 9, 2023, offenders pending charges on the docket ending in 54533S were changed from a nollie to a dismissed. And Addendum 4 states additional information from Kristen Shea, Health Management Administrator, would like BOPP to consider prior to his hearing. It is uploaded to file attachments as evidence. That was has now been labeled Exhibit I. In addition, I did receive evidence from the Defense Counsel. Oh, I put it at the end. And we have Exhibit 1 from Defense Counsel, list of parole accomplishments and future plans for parole reinstatement. Exhibit 2 is legal support, United States and Connecticut constitutions and the Americans with Disabilities Act. Exhibit 3 is the medical condition disability. Exhibit 4, allnurses.com articles. Exhibit 5 is Title 54 regulations of the Connecticut State Agency excerpts. And Exhibit 6 is the BOPP policy I-08, parole revocation policy and procedures, I section 6 evidence, and 2 principles of evidence. All evidence has been reviewed by this hearing examiner, and I will continue to review. So, okay. Now that all the evidence is on, Officer Monroe, would you like to add anything at this moment in regards to this charge for Mr. Mara?
Not necessarily with regards to the charge, but I would like a moment to just kind of talk about the totality of Mr. Mara and his charges.
Okay, so there's 2 parts to this hearing. The first part is going to be addressing the specific charges. The second part, if there is a finding made, is when we you give me background history and all of that information. So so you tell me the information that you have, is it for the first portion or the second portion?
It would be for the second portion. So no, I have nothing further to add with regards to Mr. Mara's violation.
Okay. Attorney Pam Leggetti, if you would like to address the first portion, the charges.
Yes, first off, Mr. Mara would like to thank the state for allowing us 2 continuances before this hearing to prepare. There's a lot of evidence to digest. And so just to start, we'd like to thank the state for those continuances. The first part of this proceeding, this hearing is clear. I think the regs are very clear that the sole issue is to see whether or not the state is able to meet its preponderance of the evidence burden as to charge 1. And I'm breaking that up into 2 parts, Part A and Part B. Part A, solely conduct that occurred on June 9th, and Part B, solely conduct that occurred on July 9th. As to Part A, I will obey all laws. Client was engaged in an act that was a crime. That is the language. And we must prove the elements of that crime alleged. In this case, there was a dismissal. The effect of a dismissal is that there is in fact no evidence, and the defendant under oath, under our erasure statutes, can swear that this incident never occurred. It was a non-incident. I think the fact that there's a dismissal is proof that he did not disobey the law. In this case, the case was nollied and then dismissed by Judge Zagaya, effective 11/9. And so for that reason, I don't believe the preponderance of the evidence standard is met as to the first allegation, Part A. As to Part B, this is a claim. There was no arrest. The hospital security was called. They did nothing. They decided this was a non-incident. From there, the nurse, I believe, spoke to her supervisor and called the parole officer. Sexual indecency is not a crime. For the state to meet its burden under obey all laws, there's no statement from the sole witness. It's not a recognized Connecticut crime, public sexual indecency under the statutes of the Connecticut. The report itself, exhibit, I believe it's the exhibit, the New Haven police report. There's no statement taken from the alleged victim. There is clearly there's reliability issues as that individual is the sole witness. There was no action taken by security. There's an allegation that the client may have been masturbating. That is not a crime to masturbate. Nowhere in our law is that deemed a crime. And under the elements, I will obey all laws. I must prove the elements of the crime alleged. There is no crime. There's no statute. As in an earlier report today, in another case, under obedience to the law, in order to allege a crime, a statute must be listed for us to probably, under due process, be able to challenge that. So under the 14th and 6th Amendments and Article 1, Section 8 of the Connecticut State Constitution, there's no crime listed. So he didn't disobey a law because there's no law listed. So Part B, I don't believe the preponderance of the evidence standard is met. Also, Exhibit I that has been offered as an exhibit appears to speak in two sentences as to what may or may not have occurred on June 9th and July 9th, June 9th and July 9th. I spoke with on the telephone and wrote an email to Kirsten Shea yesterday, and she confirmed what I had written to her was the topic of our conversation at 11:19 a.m., and I will read from that. Good morning, HMA Shea. It was a pleasure speaking with you this morning regarding David Mara. I took notes regarding our conversation, which she confirmed. Please confirm the following notes. Notes from conversation, and this is as to who this witness is that authored this report, as to why I believe Exhibit I should not be entertained as to any portion because of its lack of sufficient reliability, because of its immateriality, because it's not relevant, all which are required of the hearing examiner to make findings, evidence that is irrelevant, immaterial, unduly repetitious, or excludable on constitutional statutory grounds, the examiner may exclude. Kirsten Shea, HMA, served as a DOC regional supervisor role from 2018 to 2022. Kirsten Shea has met Mr. Mara, but has never provided direct care or supervision. Kirsten Shea has never witnessed or observed any incidents involving Mr. Mara. This was all confirmed by Ms. Shea. Ms. Kirsten Shea is not aware of this specific incident. Quote, I don't get into specific cases. And lastly, Kirsten Shea, which she confirmed, is not aware of the basis of the violation of parole or present allegations. End quote. So someone that is not aware of the basis of the violation of parole or present allegations certainly cannot give sufficiently reliable testimony. What essentially this letter is, Exhibit I, is an opinion. It's an unsolicited opinion. Kirsten Shea is not a witness to any charge or claim in the PVR. She's not a party. She never supervised David. She has no independent basis of knowledge, and this is not sufficiently reliable evidence. It's not evidence. It's an opinion from someone who's read dated reports, none of which is included in Exhibit I, none of it. Page 1, nothing on page 1 is regarding June 9th or July 9th. On page 2, the only two things regarding, and she has admitted that she had no information regarding the basis and is not a witness, is two sentences at the end of paragraph 2 regarding what allegedly happened regarding the dismissed charge. And so for that reason, I asked that Exhibit I be excluded as unreliable, irrelevant, unsolicited, immaterial, no probative value, and not sufficiently reliable evidence. As one more.
Oh, I'm sorry,
Yes.
go ahead. I thought you were finished.
Nope. Going on, the limited task and narrow and focused review of charges 1, parts A and B is only as to what occurred or didn't occur on those 2 dates. Relevant evidence means evidence having a tendency to make the existence of that material. It's crucial to the interpretation of a phenomenon or subject matter. Evidence is material if it's offered to prove a fact that's in dispute in this case. The only fact in dispute in this hearing is whether or not this or disobedience of the law and whether or not those elements are met regarding these allegations on June 9th and the allegations from July 9th. Please. As to also challenging the veracity or reliability of Exhibit I, my investigator yesterday, Justino Sampaio, spoke on the telephone to Patricia, defendant's mother. Patricia stated that she is very supportive of the defendant and that she also talks to the defendant via telephone, tablet, 5 days a week, 20 minutes each. And that's been going on for months. I say that this is discrediting and counters the reliability of Exhibit I because in paragraph 2, Ms. Shea writes, he is alienated from his family and has no known community supports. That is completely false. My client is not alienated from his family. And this is just proof that this Exhibit I is merely a recitation or conclusion or opinion based upon reports with Ms. Shea did not witness any of these. And so it's not sufficiently reliable. It's not independent. As the regulations state, it is immaterial, it's repetitious, and it's excludable as it is irrelevant and immaterial, and there's no sufficient indicia of reliability, excuse me. Furthermore, regarding what occurred on July 10th, it is the opinion of the defense that this could not have happened. And even if it did happen, there are no allegations that my client broke the law. To close, regarding the preponderance of the evidence standard, we don't believe that there is sufficient evidence in this case, as alleged, to conclude that the defendant violated or disobeyed the law, and in B, that the defendant disobeyed something because no law is even cited. And for those reasons, we don't believe the evidence is sufficient for the hearing examiner to make a finding regarding the preponderance of the evidence standard. Thank you.
Thank you.
Not to interrupt or cut anybody off, but I just want to clarify that he is currently being violated right now under our bail laws for the behaviors that he exhibited, and not simply just for the criminal arrest. And then also, in addition, is there any, I know you're trying to refute evidence I or Exhibit I. Is there an exhibit or anything in writing that I could get via the conversation that you had with her, or anything that stating you are refuting it?
Yes.
Because it wasn't provided to me in adequate time. So I would need time to review your exhibit that you are planning on submitting right now.
I'm not submitting an exhibit. I merely am stating that I spoke with Kirsten Shea at 11:19, and I spoke with Kirsten Shea earlier at 9:50 a.m. on 1/16, sent her an email stating the subject of that conversation, which she confirmed. I can hand the confirmation from her, which I'm not offering it as an exhibit, or I am offering it as an exhibit, but I don't believe that I have to offer this exhibit prior to this hearing. I have no burden of proof in this hearing, as my client is the defendant. I'm merely stating, as an officer of the court, that I spoke with Ms. Shea, and that is what she sent me from her email, as it states and proves there. I don't believe you, as a parole officer, have a right to object because that evidence isn't offered by you. Exhibit I isn't offered by you. Exhibit I is offered by the author of that report, Kirsten Shea, who signed it. And at the end, it says, if there are any additional questions, my contact information is below. And as defense counsel, I have a right to contact any potential witnesses separately. I don't have to notify other witnesses of what I'm doing. I don't have to file exhibits with other witnesses, and no other witnesses have a right, the hearing examiner can view it, but no other witnesses have a right to view the exhibits. I didn't have a duty to provide you with exhibits 1, 2, 3, 4. The duty only rests with the hearing examiner to provide her as a representative with it, because she is the finder of fact And in this case, as the hearing examiner, she makes the legal determinations.
Well, speaking of exhibits, then your exhibits 2 and 3, there's no author listed. So I just wanted to know, and hopefully you can clarify who the author of exhibit 2 and exhibit 3 are.
I am. I filed those exhibits.
You filed them, but you're the ones that,
I don't have to sign an exhibit because I'm the one filing.
so you came up with all of exhibit 2 and exhibit 3's information yourself?
No,
All right.
they're legal. Exhibit 2
Mhm.
and exhibit 3. Exhibit 2 are quotes from the United States Constitution, supported arguments. They're arguments. That's what they are. These are arguments ahead of time that I submitted for the hearing examiner to review, not for you to review, for the hearing examiner to review. You
Well,
have
it's
no,
also sent
you
to
have
me
no,
as evidence.
you
just-
have, but you're just a witness. You're not the hearing examiner.
I
I
understand.
mean no disrespect, but I have no duty to submit any evidence to you, and you frankly have no duty to criticize the evidence. That is
Actually,
up
all
to-
evidence goes to all parties.
Okay, well, that's,
We're gonna-
it's up to the hearing
gonna stop.
examiner, miss. This is.
All right,
we're
We're gonna stop. We're gonna stop. All right, I have a lot of information here. So I think I've gotten everything that I need from both sides at this moment. Let me
I would
just
just
review
want-
what I. Go ahead, yeah.
Okay. I am just wondering if any other exhibits would have been needed to be submitted to me for my review.
I believe
as-
you received everything that was submitted. I believe everything, I think we sent everything over to you.
Okie dokie.
All right, so exhibits 1 through 6 was submitted from defense, and I believe that our office sent that over to you.
And then we also don't need any clarification, correct, as far as who wrote exhibit 2 and 3? I'm just asking for clarification purposes.
No,
I wrote all the-
I got it. All right. A lot of information in this one, and I have reviewed all of the evidence that was provided by both sides. Taking into consideration arguments from both sides as well, their testimony today, and I appreciate testimony from both sides. So on charge number 1, obey all laws. I did break that, I am going to break that down into 2 sections. The first one being the June 9, 2023. For the charge of the disorderly conduct. I am going to be making a finding on that charge that behavior did occur. So I will be making a finding on that portion. As far as the July 10th, 2023, which is the second portion of that, I will be making a no finding on that portion of the charge as it's not written as an actual charge. Sexual indecency is not a charge. So I will be making a no finding on that portion. So that's going to conclude the fact finding portion of this hearing. Before I make recommendations, Officer Monroe, you're going to have an opportunity to speak on Mr. Mara's background and history after the state is finished. Attorney Famlighetti, you're going to be provided with that same opportunity. The purpose of this part of the revocation hearing is to help me determine what outcome I'm going to recommend. So Officer hold on, let me get a blank piece of paper. Hold on. Officer Monroe, would you like to make a statement regarding Mr. Mara's violation, background, and history at this time?
I would, thank you.
Thank you.
All right. So obviously, I'm not disputing that Mr. Mara has a slew of medical limitations and disabilities that he is currently facing with. I'm just asking that you please keep in mind the totality of the circumstances, as well as the similarity of Mara's violations, his 3 violations, since his initial release in 2021. As I mentioned, Mara was initially released on special parole for sexual assault second on September 2nd, 2021. He does have a history of serious misconducts in incident reports that date back to his release in 2021. Since that date, Mr. Mara has violated his special parole 3 times. We obviously were just made aware of his most recent violation. There was the incident on 6/9 where he attempted to throw the back brace to hit one of the workers due to the worker attempting to move Mara out of the room because Mara's belongings were soiled and dirty and it became roach infested. So at that point, Mara became very agitated and swung the back brace where the worker had to jump out of the way. And then again on the July 10th, which you said there was no finding, again, the night nurse was changing his Foley catheter and he was making sexual remarks to her about getting an erection.
She's allowed to talk.
Something where there's no finding?
There's a no finding on it, but it still can be considered during this portion of the hearing.
It was part of my initial violation.
I would still object to us.
You can
considering
object,
it
but
sanctioned because there's no finding.
I understand what you're saying. But for the totality, I can take that information.
As well as there is body cam footage. So if anyone would like the body cam footage, then.
Objection. There's no body cam footage submitted, so we can't refer to it now.
Okay.
It's the first I'm hearing of any body cam footage.
It was listed in the police report or in the police incident report at the very bottom. It says body cam
None
footage.
has been submitted.
It was submitted with the initial evidence of violation 3.
It's not. We have not seen it. No one showed it to us. It's not submitted as evidence. I don't want to argue.
Okay, I'm just saying for your
It shouldn't
reference, the
cut- it's
violation that I
just a
submitted, it was listed at the very bottom.
It's not evidence.
Okay.
In addition, with Mara violently masturbating, according to the nurse, he was also convicted for coercing a 14-year-old minor boy to perform oral sex on him in 2016. The culmination of those 2 events obviously led to his 3rd violation. Mara's 2nd violation, I'm just going to get into a little bit of that. He was re-paroled on October 22nd, 2022. There was an incident report listed on the same date that he was intaked for Cheney Halfway House. During the intake process, Mara inquired about his PO, and once Mara found out who that PO was, he angrily replied, excuse my language, fuck that cunt bitch. If she comes into this facility, I'm going to punch her in the fucking face. Later on that day, Mara's parole officer came to visit, as we are required to visit our parolees within the halfway house. And Mara replied with, fuck those cunt dyke bitches. They can go fuck one another. It is per our policy that we have to go in pairs of 2. On the next day, on October 29th, 2022, there was a Yukon Health Security incident. Mara was in the Yukon Emergency Department. He was throwing things and acting aggressively towards staff. The Yukon medical staff attempted to verbally calm Mara down, but Mara would not comply and had to be placed into a 4-point restraints. to gain compliance. On 11/4/2022, just a couple days later, there was a parole misconduct. And the misconduct read, you enter Cheney House front office and dispose of your soiled diapers in the front trash can. Staff attempted to inquire why you use the front office trash can for your soiled diaper as opposed to the trash can listed in the bathroom, or seal it in a plastic bag prior to throwing it away. Mara refused to speak with staff or answer their questions. Staff directed Mara multiple times to take the feces soiled diaper and correctly and hygienically dispose of it, which Mara failed to do so. Staff have reported that Mara knowingly leaves his diapers soaked with urine and fecal matter on the floor and refuses to dispose of them, creating an unsanitary and hostile environment. On 11/6/2022, there was another parole misconduct as well as a disciplinary action report, or otherwise known as a DAR, from the halfway house. Mara was observed by the halfway house staff attempting to take extra medication that was not prescribed to him. Staff directed multiple times for Mara to put down the extra medication and to place it back. Mara threw one of the pills, attempting to distract the staff and hide the extra medication on his person. Staff again directed Mara to put the medication back, and instead of complying, Mara placed the extra medication inside of his mouth and attempted to leave. Staff again verbally directed Mara to spit the medication out. Mara at that point turned to them and said, "Fuck you," and left the office while spitting the medication out on the floor. The DARs, the disciplinary action report that were given by the halfway house, was a Class C action, being verbally abusive to staff, Class D action, lying to staff, and Class D misuse of medication. The next day on November 7th of 2022, Mara's roommates were complaining of Mara changing his soiled diapers in the room while they were present. Mara was obviously nude on the top and the foul smelling emanating from his area. The roommates were also stated that the diapers were left in the shared bathroom floor. The roommates complained of the foul smells being left after usage and fecal matter being left on the walls, fixtures, railings, endangering the health and safety of the staff as well as the residents within the halfway house and the ones that share the bathroom. When Mara was confronted about this, he became irate and blamed his PO, stating, "She's the reason I'm here. I don't have shit because of that fucking bitch." Again, on the same day, on November 7th of 22, another parole misconduct was given, as well as a DAR from the halfway house. The halfway house staff went to have Mara sign the halfway house agreement, and Mara stated, "I'm not signing that shit." Staff again told him that the day room would be closing soon, and Mara became frustrated and angry, picking up the program's cordless phone, throwing it against the wall, and shattering it. Mara was given a Class B DAR, destruction of program property. That same day, on November 7th, again, another incident report from the halfway house. When speaking with halfway house staff, Mara stated, with regards to the halfway house, "I should burn this fucking place up. I hope it burns to the ground." Then regards to his female PO, Mara threatened her, saying, "That PO won't do a fucking thing. She's at the top of my list after I finish these 9 years. All you have to know is they haven't found any of the old bodies, and they won't find any of the new ones either." A few days later, on November 21st, 22, another DAR was given by the halfway house. Mara was in the area of the halfway house, which due to a previous sanction, he was not allowed. When staff addressed Mara, he threw his coffee cup against the hallway, saying, "This is fucking bullshit." Staff asked him to clean up his mess as well as throw away the coffee cup. Mara stated, "Fuck you, you clean this shit up." A couple days later, on November 28th, 2022, Cheney House unsuccessfully discharged Mara due to his increased behavioral outbursts, non-compliance with program requirements and rules. Mara created an environment that endangered and physical safety of staff and residents. Mara also created violent disruptions on almost a daily occurrence, destroying program property, using threatening and foul language, refusing to participate in daily cleaning, and exhibiting continuous and non-compliant violent behaviors. Obviously, Mara was only out in the community for exactly 1 month, from 10/28, and he was then violated on 11/28/2022, only serving 1 month in the community. As I previously mentioned, he was initially released onto special parole on September 2nd, 2021. On January 12th, 2022, David Mara was removed from the halfway house and placed into 60 West due to his ongoing medical issues, which I'm not denying. While Mara was at 60 West, he refused services and medical care from 60 West. He was also verbally and physically aggressive with staff. March 13th of 2022, Mara became combative and verbally aggressive with a nurse and the CNA. 911 was called. Prior to the police arriving, a male nurse staff and another male staff member were present in Mara's room. He began throwing objects and destroying property of 60 West, throwing his nightstand, breaking atop a piece of furniture, and ripping a wooden door off the hinges. Mara continued to threaten and hurt anyone who came into his room. Police were called to help gain control and assist with the transfer to the ER. Mara was later discharged from the ER that same day and brought back to 60 West. The next day, on March 14th, Mara became aggressive again and threatened to stab staff with a fork. Mara proceeded to throw his BiPAP machine and other objects within reach. Mara also tore the second wooden closet door right off the hinges and was threatening to break the glass window. Additionally, he threatened staff, stating he was going to call his friends to come to the facility with an acid gun and shoot them. Mara was transferred again to the ER with police support and later released back to 60 West. The next day, on March 15th, 60 West determined that due to Mara's continued and increasingly dangerous and threatening behaviors, along with his refusal to accept services, he would no longer be allowed to reside there. 60 West did submit a discharge letter stating, due to David Mara's threatening and dangerous behavior and his continuous refusals to accept assistance with care and services, we feel he is not appropriate to reside in the skilled nursing home environment. That same day, on March 15th, Mara moved into Chelsea Place Care Nursing Home. While his time at Chelsea Place, Mara's aggressive behavior became increasingly more volatile. Mara caused significant property damage to the facility. In addition, he made several verbal threats towards staff, through an oxygen tank, metal meal trays, and other items within his reach and staff. Mara also punched multiple holes in walls behind his bed. Where the holes were repaired, he would punch holes in the walls again. Mara tore down sheetrock in his room, exposing the inside of the wall. Mara also made several attempts to kick open the secure doors in an attempt to escape. He was subsequently violated with his first violation. And I would just like to say Mara has refused countless times to demonstrate his willingness to comply with rules in different nursing homes, halfway houses, state laws, and parole conditions. He's repeatedly proven to be violent with those providing care for him and those supervising him, and exhibits violent and dangerous behaviors when he is challenged or questioned. Mara's behavior remains inconsistent with any goal of reintegration to the community and is not appropriate for community supervision, as he has a high propensity for violence and is a threat to community safety. All of these previous behaviors that I've mentioned go toward why Mara has been banned from 60 West and all other eye-care skilled nursing facilities within the state. To date, parole as well as DOC discharge planners have not been able to find a nursing facility in the state willing to accept Mara with all of his behaviors and aggressive states.
Thank you.
Yep.
All right, I've officially run out of ink on that pen.
Um,
No, I have another one.
Okay.
I always come prepared. Always come prepared. Sure. Okay, Attorney Van Ligeti.
What we've just heard is essentially a litany of what's going on with my client allegedly over the past few years. I don't believe that at the time of his last revocation, which was back in early 2023, I'm holding a copy of the 5-page revocation summary, much of which this witness just read from, or I could go along with when the witness was testifying, was addressed. All the past. The only thing that's changed are these two alleged incidents that are referred to in the parole violation report that's the subject of this hearing. Everything that happened prior to that, in terms of a parole violation and sanction, was addressed and is summarized in a revocation hearing summary, status final, dated 2/14/23. Goes on to talk about threats made towards parole officer Pham. Fuck that cunt bitch. All this stuff that just was listed. He threatened to commit arson and burn the halfway house. All of this. Residents at the Cheney house were leaving your feces-soiled diapers. You were observed in the computer room being restricted. You were unsuccessfully discharged from the job. All of this conduct and everything prior that happened in 2023, that happened in 2022, that happened in 2021. What we just heard is a recitation of things that have already been dealt with by the board. There's no doubt that my client is disabled. Everyone has admitted that. It's uncontradicted in the evidence. There's probably no doubt that my client may be difficult to deal with at times because he's suffering from a disability. Many of these times when he's acting out, he's advocating to alleviate pain and advocating for one's medical needs, which exist as a result of his disability. It's determined to be aggressive because he's the one in pain. He's the one not receiving the appropriate treatment. What we're facing here is a disorderly conduct. The regulations themselves define what a violent offense is. Violent offense is defined by our regs as any offense for which an individual is convicted and which causes such individual's eligibility for parole release to be subject to the provisions of section 54-125A. He was not convicted of this, so it is not a violent offense, and no finding can be made as regarding this dismissed charge being a violent offense. Clearly, it goes on 54-124A per open paren J close paren open paren 2 close paren -1A. This is exhibit 5 I'm reading from, definitions, subsection 8. Violent offense goes on in its definition to list crimes that the regs define as violent offenses. Interestingly enough, even if you were convicted of disorderly conduct 153A-182 is not defined as a violent offense in section 54-124AJ2-1A8. Neither is threatening 1. Neither is threatening 2. None of his conduct in any way, shape, or form, because he's charged with disorderly conduct, which was dismissed. He was not convicted as is required to define as a violent offense by the own regulations of this board. I will argue, and I will contend that none of the offenses in obedience to the law, the finding regarding Part A, that is not a violent offense as described. It was a dismissal, so I don't believe that it should be considered whatsoever. All of the conduct, all of my clients' difficulties, all of my clients' past transgressions were dealt with and sanctioned in the first 2 of his now 3 hearings, revocation hearings. At the last revocation hearing, there were more than 1 findings. There was a finding as obedience to the law. There was a finding as to halfway house placement. There were other findings made. He was represented by Attorney Sirica of our office, and I spoke with him about this. All of these findings, the board saw fit to sanction him to 4 months. If anything, he shouldn't be sanctioned at all in this case because all we have here is an allegation, not a conviction, that he committed the crime of threatening to and disorderly conduct. And neither of those are recognizable violent offenses. As such, my client is appropriate to be released into the community. It is not and should not be an argument that my client is not appropriate to be released into the community because agents of the Board of Parole can't find a placement for him. That's unconstitutional. It's cruel and unusual punishment to require my client to sit in jail because you can't find a placement for him regardless of the reason. You'll have to find somewhere to place my client because jail is not an appropriate alternative. It's unconscionable, it's unconstitutional, constitutional and it's a violation of the ADA to discriminate against someone because of their disability. This is what's going on in this case. My client is difficult to deal with, admittedly, because he's suffering, he's in pain. That's not a reason as a sanction to incarcerate my client and make him serve additional jail time. He's been held since September because of a dismissed charge. He's been held September to October, October to November, November to December, December to January. This whole time, he's not been receiving appropriate care because of one finding made in this report that this incident occurred, even though it's been dismissed, even though it's a nonviolent incident. He's on special parole. The policy states that the board own policy states that unless a finding is made that the defendant is violent, unless a finding is made that this is a violent offense, he's to be released at the next available release date. We're asking that my client, as this is not a violent offense, as no finding is able to be made, that pursuant to the policy, my client be released on January 25th. Or if no finding was made today, we'd ask that it be released today. I understand that's not possible because the finding was made today, but we're asking that he be released. And I think there's only one conclusion to be drawn logically, that he should be released pursuant to the policy, because this is not a violent offense, on January 25th, 2024. Thank you. Not sure if my client has anything to say.
The only thing I got to say is about the allegation of throwing my brace or whatever. He claims that he came in, he's not authorized to even transport me into my wheelchair, first of all. Second of all, he was threatening me, telling me if I didn't get in the wheelchair, he was going to throw me in the wheelchair. Third of all, he's saying that my clothes were dirty when they were all brand new and they were bought by the halfway house. They still had tags on them. Third, he said they had cockroaches. There was cockroaches at the facility. They didn't come from me because the halfway house bagged up my stuff and they didn't have no cockroaches. So how did they get in the bags? And when the ambulance showed up, he put 4 of my bags in the ambulance. So why would he put cockroach infested dirty clothes in a sanitary ambulance if he knew they were dirty and everything, or cockroach infested? Because it was all false. He's just trying to point at me about the whole thing. As far as throwing my brace, if he was sitting in front of me, my wheelchair was in front of me, that would be at least another 4 or 5 feet. And I'm having problems even gripping utensils. So how did I even hold the brace or even reach him if he was sitting in the bed across from me that was over 6 feet away?
Thank you,
That
sir.
don't make sense. So 90% of his story is proven false. Don't you think that his allegations probably false too? And that's just one. I mean, all of these are just false. Saying I kicked open security doors when I'm in a wheelchair and I can't kick nothing. It even says in there, I ran across the parking lot and they had to chase after me.
So this is all in the past. They've already sanctioned you regarding that, so it's not relevant to today's proceeding.
But they're all false.
I understand.
They enhance on them every time I hear it.
I understand.
All right, I'm going to take a recess to consider all of this evidence. And I'll be back with all of you. If you want to, please. Thank you. Yep. Okay, back on the record for David Mara, inmate number 413857. Okay, it was a lot of information, as I stated earlier, a lot of information to go through, a lot of evidence on both sides. I have reviewed all of the pertinent information. I'm taking everything into consideration as far as the evidence that is valid. So, Mr. Mara,
Yeah,
I am recommending that your parole be revoked.
thank you.
Oh, I apologize. Hold on.
Yeah,
Hold on. Apparently I didn't have the camera on me, which is okay, because I don't like to be on the spotlight. All right, let me start over. I am recommending that your parole be revoked and that you do serve an approximately 2-year sanction. I'm with a release date of September 18th, 2025, with the conditions of behavioral management for anger management, no contact with your victims, the minor, the mother of the minor, initials DD, or with JC, a general no contact with minors, problem sexual behavior in the community, mental health treatment, as well as halfway house placement. My findings and recommendations are going to be forwarded to the board. The board is tentatively scheduled to review this on January 25th, 2024. Again, I say tentatively. The board may lessen the recommended sanction or let my recommended sanction stand, or they may impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, a supplemental hearing will be held, and before that hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. And during the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. My reasons and my summary will be provided to all parties. In the next couple of days, you'll be receiving it, and they will be sent out to each of the interested parties on them. So this is going to conclude the revocation hearing. I'm going to go off the record for David Mara, inmate number 413857. Good luck to you, sir. Thank you, Officer Monroe. Thank you, Attorney Famighetti.
Thank you.
Thank you.
Mr. Mara, give me a call. I'm sure I'll talk to you before the 26th of January. Okay, but make sure you call me on the 26th of January so I can tell you what the board decided. Okay, sir?
yes, sir.
Okay, have a good day, sir. Take care, officer.
Bye.
Bye.
Then
Yeah, it was fun.
No, please don't take this person.
Okay, so how do we unpack what we just saw? I mean, it is unbelievable. How is it possible that a state of Connecticut says that there's no offense for sexual indecency? So basically, someone who is a convicted sex offender can masturbate in front of a nurse, and there's nothing wrong with it, apparently. Whoa, okay. That's different, but I guess you you get what you vote for. I don't know what to say. I mean, this guy, we're gonna unpack this, but it's the whole thing is just such a mockery of the system. Now, you got to give his public defender who just does revocation cases, I guess you got to give him credit. I mean, the guy's fighting for his client as if he's a top paid celebrity. And I guess, hey, everyone should have some type of proper representation, but I felt he took it a little too far. I mean, he's like raging on, it felt like the parole officer, discrediting the parole officer, going on these like tangents with so much veracity, and finishing off with, yeah, my client's disabled, but he's the one in pain. He's the one uncomfortable. That's why he's throwing his feces all over the place and masturbating in public and throwing his back braces and punching through walls. And it's just, the list goes, it's him. He needs the help. It's like, shut up, man. This guy is nothing but a leech on society. And it's disgusting that the system has to keep putting up with him. And we'll go through some things, or we'll talk about that Richard found, just to emphasize this fact. But keep in mind that he was offered a plea deal. It doesn't say what in here, but what happened is that there was a boy which he sexually assaulted 5 times. This boy is, I think, 14 years old and 15 years old. And the boy, 13 to 15, right? And the boy was brave enough at 20 years old. He went to the police station and filed a complaint. We'll go over this in more detail. Now, they offered him a plea deal, but he turned it down. So then they went to trial. Now, it doesn't say, again, what the plea deal was, but they went to trial. A jury found him guilty. I'm guessing that the victim the survivor had to get up there and testify. And what does a Connecticut judge give him? He served 5 years before getting out on special parole. That was it. It's this Connecticut stuff. They're nuts. They're absolutely nuts. And then since then, from my understanding, from what I heard, he's been revoked on his special parole 3 times. 2021, 2022, 2023, and now 2024. And he was revoked. So we waited until like the 21st. They have like the special parole board that actually makes the ultimate decision, and they made the decision to revoke him. So if you were wondering what the outcome was, they did revoke him. It's like they have a special hearing where they just go over it. Now, here it is that an Enfield man arrested on October 2014 in charges of molestation of a teenage boy on several occasions 6 years earlier was convicted by Superior Court on Thursday. David, who is 50 years old at the time, how do I make this like, you know, it's just, why is it hard to get the screen correct? I guess they really want all of us to see those ads. It's so important for us to see the ads, right? That's probably it. I don't know. I'll just he'd been charged. Okay, so he opted to go to trial. You would think you go to trial, you lose it. Maybe, you know, I get a proper punishment, but you know, whatever. 5 years is apparently proper. He had originally been charged with 2 counts of second-degree sexual assault of a victim between 13 and 15 and 1 count of illegal sexual contact. The jury found him guilty of second-degree sexual assault and 3 counts of risk to injury to a minor. He is scheduled to be sentenced April 29th. An affidavit supporting Mara's arrest says that 20-year-old male filed a complaint with the Enfield Police Department July 2014, alleging Mara had molested him on 5 occasions in the summer of 2008 when he was just 14 years old. The alleged victim said his family on the maternal side had a close relationship with the Mara family for decades. Detective Dave Thomas wrote in the arrest warrant application. During the summer of 2007, the alleged victim was hired to do lawn care, and the first occasion of sexual contact between Mara and the teenager was in the summer of 2008. The boy told police he and Mara had engaged in oral sex 5 times, twice in Mara's bedroom, twice in a living room, once in the garage, the affidavit states. And they have a thing here where there was another witness, and maybe that helped convict him. At the time of the third encounter, the pair were engaged in oral sex in Mara's bedroom when a man described as Mara's boyfriend, so the King Roach's boyfriend, walked in on them. The boyfriend said he had a prearranged date with the King Roach, but it was canceled without notice. So he was suspicious and came in there and saw them together. Can't make this stuff up. And then this is I just make sure everyone scrolls. So see, release date September 2nd, 2021. They convicted 7/27/16. That's 5 years. Release date 9/2/2021. I mean, it's just like, that's it. That's it. And then he goes through what he went through. It's just unbelievable that we have to suffer these type of monsters. Can you imagine having to be put through, and we'll go through something else, having to be to go through this type of stuff, to have to suffer through someone like this, talking about how he's throwing his feces all around the room. And you know what I picked up on, just my opinion, I don't know if you did, but when she was reciting all of the instance of how he had thrown his diaper in the trash, and he was David, the King Roach, it looked to me like he was getting pleasure out of hearing it. Like he got this big grin on his face, and it was as if he was taken back and he was getting excitement from hearing about his disgusting behavior. You know, someone might interpret it that he was embarrassed. That's just not how I interpreted it. It was like his face lit up. And, you know, you see him get wheeled in there with the hand braces and the wheelchair, and you're like, really? How is it? But I believe every word of it. I think this guy is every bit as bad as they say it is, and he's a menace to society and belongs and needs to be in prison. There are some people that just don't belong to be amongst us, because why should we all suffer? And why should everyone suffer due to his really just disgusting behavior? You know, it's almost like, okay, attorney, why don't you go have him move in with you? You really put up a good fight. I mean, and I thought it was a good fight he put up. We don't see this type of stuff. You would think that he's, you know, just the veracity of his argument. You would think that it's like it makes me wonder, what is he doing at a parole revocation public defender's office? Like, why is he not, like, you know, an ADA for murder cases? He's bringing up statutes, and he's bringing up the Connecticut Constitution, and he's trying to like to discredit the parole board member. And I wonder if it's a good strategy or not to do what he does to parole officers. I mean, these are people that you need to play in the playground with a lot, and to have a reputation of someone who is just discrediting a parole officer like that, I can't imagine that that's a good strategy. You know, just big picture, everything career-wise and even winning case-wise, like, you know, it's something I've just never seen before. But now here's something that Richard found, which has nothing associated with this case, but I think paints a picture to the kind of person this King Roach is. So this was a civil lawsuit that one of his neighbors filed against him, and which they won the lawsuit. And it's unbelievable what he was doing. It turns out he's a racist. He's a bigot. He's just like everything. He's just the worst of the worst. And, you know, he would do things, it mentioned the lawsuit, he would stand up and watch his neighbor's daughter swim while he would presumably touch himself, right? Like, these are the type of things that he was doing as a menace to his neighbor. Now here's, I'm just going through this 38 pages. We're not going to go through all of that, but we'll touch on some of the major points here. So the count includes 1, intimidation based on bigotry or bias pursuant to Connecticut General Statute, invasion of privacy based on publicity, the unreasonable places, and false light before public. It goes on to all the different things that he's done, voyeurism pursuant to the statute, right? I mean, this guy, he fell under everything. And then look at one of the things that he did on July 5th, 2003. I'm not going to read this. You just look where I'm highlighting. He wrote that in large white letters on the left side of his truck to the members of the Park family, and neighbors passing could read it. He also wrote this. Okay, this is the prince that he's in pain and feel bad for him, right? Directed at in reference to parents being a different. Yeah, okay. I mean, you just see it. You just see it. He's disgusting, and I like, to the point where this poor family had to actually sue him. As a result, Mara's injurious acts, Parks alleged to have suffered loss of sleep, persistent crying, loss of appetite, anxiety, mental anguish. And, you know, there's like those series of Neighbor from, you know, Hell or Nightmarish Neighbor. Mara allegedly even gave his offensive gesture the elderly, widowed Mara's offenses and repeated steering has allegedly resulted in Emma's teenage girlfriends being forbidden by their parents to swim in the swimming pool. You know, because of his steering, they wouldn't even they lost like their happiness. This monster took it from them. This video camera purported had a motion sensor that would begin taping whenever there was movement within the bedroom of the teenager. Can you imagine? He had a camera set up so whenever their teenager went into the house, it would start filming. Went into her bedroom through her window. Like, I mean, it goes on and on and on. I can drop this link in the description if you want, but it was just a civil. You know, apparently they couldn't file any actual law, so they did a civil lawsuit and they won. It's not clear. Let me see if I can. Oh, it actually doesn't look like a happy ending at all. I paused it to read through it again. So it looks like what happened is that they sued the homeowner's insurance policy because, of course, they would get nothing from the Roach, and then the Roach. It seems that the Roach insurance company, if I'm understanding this correctly, basically said, no, we're not responsible for what he does. It's just not something that we're responsible for. And it seems that this poor family lost that lawsuit and was responsible to pay for the cost of the lawsuit. So they're basically saying that there is no reason for them to defend, has no duty to indemnify. Plaintiff Middlesex motion for summary judgment is hereby granted. The court hereby declares and judges that the plaintiff Middlesex Insurance Company has no duty to defend or indemnify the defendant. The Parks family in the Connecticut Court and Judicial District of Hartford. The clerk directed to terminate the case with cost of the plaintiff. That's too bad. You know, they were trying to get something, but it seems they're just saying that his homeowner insurance policy they provide liability damage for injury, blah, 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 defined as an accident, but they're not going to provide it for like what he did, which makes sense. I mean, I don't know why they thought homeowner insurance would provide something like this. But anyways, I mean, it's just I guess one thing, they were lucky he's locked up. They're lucky that he's in prison there. But can you imagine having a neighbor from hell like that and there's nothing that you can do? There's just nothing that you can do but move. And it's like roaches like this that just are and the worst part is that it's like the system's designed to protect them. You know, I mean, he refuses a plea deal after what he does to this little boy. The boy's brave enough to fight him. They go to court. A jury finds him guilty, and they still only lock him away for 5 years. He gets out on special parole. He violates 3 times, and he's just a menace to society, wreaking havoc, literally throwing feces around the room, attacking people, assaulting nurses. It's just, and the system just keeps saying, good boy, that's a good boy. Now I know they revoked him, but I can't remember how long it's for. Is it 2 years or something? But it's disturbing. And you probably wouldn't believe it if you didn't see it, but here you did. And with that, I'll let you go.